All right, as we've discussed, last week, Louisiana Governor Jeff Landry signed into law legislation making his state the first in the nation to require the Ten Commandments be posted in every public school classroom. Well, the ACLU and other groups wasted no time. They've filed a lawsuit today challenging this law. But many experts believe that in anticipation of the lawsuit, the legislation's authors constructed a law, the language within this law that's going to satisfy legal precedents. Well, joining me now to explain this is Liberty Counsel's founder and chairman, Matt Staver. Matt, welcome to the program. Always an honor to have you, my friend.
Thank you, Jody. Good to be with you in FRC.
Well, thank you so much. Look, before we just get into the details of this particular law and all that sort of stuff, just a general history. I mean, when we come to a constitutional law, our country's founders, it's well documented. They had a good understanding of the Ten Commandments being the basis for our laws and our legal system. So with that backdrop, why would someone oppose public school students, children, from gaining a better understanding, gaining a better appreciation of the foundational documents that our states and our national government really relies upon when it comes to legal matters and how we stand?
Well, you know, the ACLU and groups like Freedom from Religion Foundation, they have an agenda, and that is to wipe away anything that has a Judeo-Christian heritage or history. And certainly the Ten Commandments predate America. I wrote a booklet called The 10 Commandments in American Law and Government, going through all 10 of the commandments. And I did this based on litigation where we were defending the Ten Commandments displays all the way up to the United States Supreme Court. We, since 2005, when the Supreme Court issued some decisions on this issue, we've never lost a Ten Commandments case, whether it's a standalone case or it's a case in the context of other legal documents like the Declaration of Independence, the Constitution, Magna Carta, and so forth. If you go back to the Ten Commandments, prior to even the founding of America, they have, for thousands of years, influenced law and government societies, and certainly had a big influence in Europe. That influence carried over here in the United States. And that's why when you go to the United States Supreme Court, the most prominent display of any symbol in this court, inside and outside, is the Ten Commandments, which appears around 50 times, both inside and outside of the U.S. Supreme Court. Amazingly, the actual official seal of the Ninth Circuit Court of Appeals, which has been infamously known to be a very activist court, that particular seal has the Ten Commandments as part of it. It is prominent all over the United States. Why? Because it is critically important and influential in American law and government. In fact, if you go back to many of our early states and our judiciary laws and many court decisions, they actually reference the Ten Commandments when we are referring to laws such as theft, murder, being truthful under oath, and so forth. All 10 of the Ten Commandments have been cited as bases for law, like, for example, blasphemy laws, where we talk about libel or defamation in the context of this would be referring to some of the first 4 of the Ten Commandments. Very influential. What we have seen, however, is back in the 1970s, an activist Supreme Court. Today, we celebrate the overturning of Roe versus Wade from 1973. Well, 2 years ago this month, and in the term of the Supreme Court 2 years ago, a court also overturned the 1971 decision, Lemon versus Kurtzman, from that liberal 70s. And it was that decision that caused all kinds of chaos and havoc. But even under that decision of Lemon versus Kurtzman, which distorted the First Amendment free exercise, Establishment Clause, and free speech clauses, even under that, we won time after time after time Ten Commandment cases. Now, with Lemon being overturned as of 2 years ago, the Supreme Court says we need to go back to a historical approach to the Establishment Clause. And when you do that with the Ten Commandments, that's exactly why Louisiana took this opportunity to pass this law. They are on very good legal standing.
Yeah, that's exactly where I was hoping we would lead into, because you know this as good as anyone, both the history and the legal standing, the legal foundation that this Louisiana law is standing on. So you feel good as with the language that they put into this. As I understand, they're referencing some U.S. Supreme Court rulings, as you just mentioned, some of those in the language that they have. Why is this going to be so important, this case?
Well, I think it's very important because it's one of the first cases post the overturning of Lemon versus Kurtzman in 2022 that actually addresses a religious symbol. Now, we've had other cases involving free speech. Our case that was part of overturning Lemon was the Shirtliff versus City of Boston, where they used Lemon to censor private Christian viewpoints. The other case was the Coach Kennedy case. Those two combined together, they used Lemon to censor private viewpoints. But Lemon is gone. It's over. It can no longer be cited. 7,000 times was it cited or referenced in law review articles, and now it's history. Now we go back to a historical approach. And what the Tennessee legislature did is they actually cited cases such as the Van Orden case that came out of Texas with the standalone monument that upheld that standalone monument. But even greater than that is this new sea change. So I think it's very important, Jody, because this is one of the first of many states and also displays and other issues that are flowing out of this sea change of 2022. We certainly remember that Roe was overturned 2 years ago today, but also this was a huge change in 51 years of bad Supreme Court precedent, and now we're focused on a historical approach to the First Amendment. That is huge, not only for the 10 Commandments in public schools or the 10 Commandments in public places, but nativity scenes, other kinds of expression of religious, particularly Christian viewpoints, whether they're Bible clubs or churches. So many different changes. We have more freedom now than we had clearly 2 years ago. And we need to exercise that freedom. And that's what we're seeing in this law. I think we will see many states follow the lead of this particular development.
Yeah, I was in fact talking with one of your colleagues about a month or so ago about this very thing. And this is one of those things, Matt, that seems to be kind of going under the radar. It is a huge decision, but it has not been made very public. You know, we hear a lot about the Lemon test. I got several things I want to ask you here. A lot of talk about the Lemon test. If we can just first explain what is meant by that phrase, the Lemon test, but also just how huge this whole reversal of Lemon is. You've just gotten into it, but this is just as you just alluded to, from nativity scenes to a host of things. This is a huge decision. Well, let's begin. What's meant by the Lemon test?
Yeah, it comes from a 1971 case called Lemon versus Kurtzman. And in that case, the Supreme Court developed 3 tests to determine whether something violates the First Amendment Establishment Clause. And in doing so, they distorted and twisted the First Amendment. So this is the beginning of the 70s activism. You have 71 on Lemon, you have 73 on abortion, you have 77 with regards to protection for people of faith in the workplace, and they gutted that. That was overturned 1 year ago. And then you had 78, the affirmative action admissions to colleges and universities, all from the 70s activist court, because they didn't like faith, they didn't like Christianity, they were pro-death, and they had a very liberal activist bent. So Lemon versus Kurtzman was a case that was used, and that's where we get the word Lemon test, 3-part test. And that test was used to allow a lot of subjectivity. For an example, a nativity scene could be constitutional if it was set up by the government, like the city wanted to have their own nativity display, but it depended upon how many other secular symbols of the holiday were in that display. And it also depended upon how close they were. Was Santa Claus close enough to the nativity? You know, was a Christmas tree secular or was it sacred? You know, was it close in proximity to the nativity scene? And sometimes you'd have to get out your measuring stick to decide whether or not this is constitutional or not. It was really nonsensical. So it allowed a lot of judges just to wield autocratic authority based upon their own ideology to strike down a religious display or to uphold it. And basically everything. I mean, I remember a situation where the Ten Commandments was literally etched on the courthouse wall in Philadelphia. And during a lower court decision, which struck it down, they covered it while it was up on appeal. And thank God on appeal, the Court of Appeals reversed it. But they were going to literally chisel, if the Court of Appeals went the wrong way, chisel that off the outside of this courthouse that had been there for decades and decades. So that's the kind of nonsense that we faced. Now, thank goodness, we're looking at the First Amendment from its historical meaning and purpose. And when you look at that in the context, I mean, the Ten Commandments, more than any other document through thousands of years, but certainly in America, have more than any other document influenced our American law and government. We don't have our laws that we have now, absent the Ten Commandments. They clearly grew out of the Ten Commandments and were shaped by the Ten Commandments. So no wonder why it would be an appropriate display in schools as well as in public places. And that's why we've seen it in so many different locations. But, you know, they want to keep they would rather keep the Ten Commandments about not murdering, not stealing, honor God, honor your parents. They'd rather keep that from their view while they indoctrinate them and make, you know, people protesters and, you know, anti-American. I think this is a great move by Louisiana, and I think it'll be upheld. Certainly, we will file an amicus brief in support. We have lots and lots and lots of research. It frankly is amazing, this area of research. I was amazed when we delved into it back in the early 2000s as to how much the Ten Commandments literally have shaped our American law and government. We would not be the same country without the Ten Commandments.
Yeah, in fact, it was during the early 10,000s, while I was a pastor, that it was this Ten Commandment issue that helped the Lord use to transition me from the pulpit into more political involvement to the extent of going to Congress. But you mentioned the moral issue here. There's a lot of people, I'm sure the ACLU will, part of their argument will be you can't be cramming your morality down the minds of these children, these students. But this is more than that. In the first place, they are cramming their immorality down the minds of our children with their transgender and their LGBT and all this kind of stuff. It is their religion, really, that they are cramming immorality down the throats of our children and our culture for that matter. But you bring up the whole historical role of the Ten Commandments and how they have played such an enormous role in the founding of our country and our legal system. All of this is a huge distinction in this argument that's going to unfold as this moves forward.
Yeah, really it is. I mean, it is really surprising when you go into the United States Supreme Court. The fifth symbol around the great room when you walk in up the big steps to go into the Supreme Court, every fifth symbol is the profile of Moses with the Ten Commandments. When you walk in, the double doors, the Ten Commandments are etched on both double doors. A lot of times you don't see it because the doors are open when you walk in. When you sit in the pew and you exit, the Ten Commandments is at eye level on each pew, both to the right and to the left. The Ten Commandments is the only document that actually is written inside the Supreme Court. And on the outside of the Supreme Court, Moses occupies on the backside of the Supreme Court the very central seat, holding the Ten Commandments with all the other lawgivers looking up to him. And that is because, well, you know, the Supreme Court was created, that building was in the 1930s. But when you go through our country, you go like to the Ninth Circuit Court of Appeals. The Ninth Circuit Court of Appeals is 100 plus years old, that seal. And that's why it's there. It's a court of law. And the shorthand of that is the Ten Commandments. In fact, if you go on, say, a Google search for different kinds of research, and you type in 10 Commandments of, and have like an ellipsis, it'll pull up tens of thousands of documents that will say something like the 10 Commandments of gardening, 10 Commandments of building a better house, the 10 Commandments of fixing your roof. Why is that? Because the 10 Commandments have been a shorthand for a rule of law. So we use it in practical sense, but we've used it in a government sense and in a legal sense. It literally has shaped everything about our legal and governmental system in the United States, and not just in the United States, throughout Europe and throughout decades. I should say millennia of human history.
Matt Staver, founder and chairman of Liberty Counsel, I can't thank you enough. Liberty Counsel has done so much on this issue and so many, many other issues as well. We all just say thank you for your leadership and the incredible work of Liberty Counsel as well. Thank you for joining us today on Washington Watch. It's always an honor.